Hi folks, law schools spend 3 years and people spend thousands of dollars to try to learn to think like a lawyer. In this video, I'm going to teach you how to do it in 3 steps. Before I do it, I'm going to tell a joke. I don't know how good a joke it is, but it will illustrate my point. A fellow goes to a math teacher and he says, 2 plus 2 equals what? Math teacher says, well, that's easy, it's 4. Goes to his accountant, says to the accountant, what's 2 plus 2? The accountant says, let me get out my calculator. Does all of the calculations, and he comes back, he says, it's 4. Last he goes to a lawyer. He said, 2 plus 2 is how much? The lawyer kind of says, looks around, pulls down the shades, turns off the lights, and he says, what do you want it to be? Now the point is that lawyers don't think like normal people. And in law, that's because of the way that they train lawyers in law school on how to think. And lawyers themselves don't always recognize what they're doing, but they teach you 3 primary things. And so these 3 things are, number 1, as a lawyer, you have to learn to challenge whatever kind of conclusions are drawn from facts. The second thing that you need to learn to do is to be able to dispute something that's not even accepted as a fact. And the third thing is you need to learn to challenge the definitions and meanings and interpretations of laws. So let me give you an example and explain all of these. First thing, let's say a guy is driving and he's arrested by a police officer for drunk driving. And comes to court and they say, oh, he has red, bloodshot eyes. His defense lawyer accepts that as a fact. In other words, a fact is something that it is accepted. Nobody's disputing whether or not his eyes were bloodshot or not. In those instances, what lawyers tend to dispute is, well, what interpretation or what meaning do we draw from that fact? Prosecutor says, he had red, bloodshot eyes. Therefore, he must have been guilty of drunk driving because, when you're drunk, your eyes are red and bloodshot. The defense lawyer says, wait a second. We're not arguing that he didn't have red bloodshot eyes, but red bloodshot eyes, he was in a smoky bar, he has hay fever, he was up late. The fact that his eyes were red and bloodshot, that doesn't mean he was driving drunk. It can mean any number of other things. So here what the lawyers are arguing about is, well, what do you interpret from those facts? What does it mean? The second thing that lawyers do is argue about whether or not something is a fact. Do they dispute something to be a fact? Let's go back to the bloodshot eyes. Officer Hammer comes to court and he says, this man had red, bloodshot eyes at the time of his arrest. Defense lawyer, this time, he doesn't accept that as a fact. He brings in the accused's friend who was with him all night and says, no, his eyes weren't red and bloodshot. He brings in a booking photo and says, ladies and gentlemen, do those eyes look red and bloodshot? He brings in the booking clerk. He says, that exactly how he looked? Yes, it is. So there the lawyers are fighting about whether or not something is even a fact at all. A similar kind of process goes on in the interpretation and arguments about laws. So the most famous example is we have a law. The law says no vehicles in the park. One day there's a man and he is in a wheelchair and he is in the park. Officer Jones comes and he arrests the guy because he's in the wheelchair in the park. Goes to court. Prosecutor says, ladies and gentlemen, a vehicle is a vehicle. This guy, he's in a wheelchair. I know you may be feeling sorry for him, but he was in a vehicle, he was in the park, he's guilty. The defense lawyer says, wait a second. For purposes of the law, a wheelchair, they never could have meant a wheelchair to mean a vehicle. They must have meant motor vehicles, motorcycles, trucks, cars, things that'll tear up the grass. They never meant for a wheelchair to be considered a vehicle for these purposes. So now if you pay close attention, they're doing things that are similar to in the factual example. The prosecutor is saying, hey, a wheelchair is a wheelchair and that's a fact. Defense lawyer is saying, he's disputing whether it is a fact and saying, no, it's an issue that's being disputed. Now, if you think it's crazy and that's a crazy example, it's not. Lawyers do this kind of thing all the time. For example, in a DUI, let's say a drunken cowboy in a drunk driving case. A drunken cowboy comes riding into town on his horse. Alabama law says, you would think, well, a horse is a horse, of course. No. Alabama law says that a horse is a vehicle for purposes of the drunk driving law. So because a horse is a vehicle, that person would be guilty of drunk driving. Of course, you think, and lawyers previously argued until they lost in court, lawyers said, well, wait, a horse isn't a vehicle, it's an animal. And a person rides a horse, they don't drive a horse. Some judge, the appellate judge, said, that's not so. And so this is the kind of things that lawyers do and fight about. I certainly hope that you're not in any kind of a legal jam. If you are and you need our help, just give us a call here at Segal & Segal. I'm Andy Segal, and I practice with my wife, Andrew Segal. Our phone number's below. I hope you found this video to be helpful and enjoyable. Thanks for watching.